what is the importance of a shareholders agreement? The question actually said, what is the importance of a shareholders agreement in a small business? But actually, I think it's important to have a shareholders agreement in any business, regardless of size. So I'll hand over to you for your answer.
Thank you. I don't know. I thought about it in advance, obviously, because I cheated in terms of a small business. But as you say, it is important for any business. But the larger businesses tend to put them in place a bit more because there's more to protect. So therefore, small businesses don't think about it. In terms of what's in a shareholders agreement that's so important, it basically looks at things like director decisions, restrictions if someone's to exit the business, any shareholder exits the business, dividend policy, which for most people in the business is rather important as a shareholder, and things like that. So it's basically in advance, you're sitting there and going, right, these are key important factors that we need to think about. Let's make our decisions now and all agree to it and sign it into a legal contract, and therefore anyone can sue on that if the company or the shareholders don't abide by it, especially the directors. So instead of it all coming up later on, 3 years down the line, oh, I want to take this money out of the business, well, that's not what we agreed, prove it, etc. It can all implode, and suddenly you haven't got a business anymore because the shareholders are fighting, and it can basically kill the business off. So you often see a lot of businesses die because of infighting for things that hadn't been thought about in advance and put down and put into a legal agreement. In terms of a big business, or certainly a bigger business when it's not just two people, 50-50 or something like that, one of the key points in the shareholder agreement is the minority protection side of things. So there's often a schedule where it says the following decisions cannot be made by the board without the consent of 80%, 90%, 100% of shareholders. So it just gives minority shareholders that are putting their investment in that little bit of safety over what's been agreed in advance are important decisions for them. So essentially it's just there to protect the shareholders, especially those that don't have the decision-making abilities.
So it's like a rule book that you do at the start, yes, to prevent potential arguing that could end up in court.
Exactly, and a lot of companies, a lot of companies rely on say, well, we've got the articles in place. If you just rely on the articles, especially a lot of companies start with the model articles, it's going to go nowhere near any of the decisions that a shareholders agreement does. It's just the generic things. It's not going to go into what suits this company best and how this company should do things. It's all just generic. So if you're relying on the model articles or any articles, normally it doesn't go far enough. It doesn't become a rule book. It becomes just guidance in generic situations.
It can connect and overlap into my field as well, can't it? Because you can state what you want to happen in the event somebody passes away. So it's useful for that as well, isn't it? Yeah.
And it protects often in that case as well. A lot of people, as part of shareholder agreement, say that some people have to get policies put in trust in terms of buying the shares back so that it protects the estates of the family while deciding that the shares go back to the company, so as to not let new people in, but make sure those people are properly compensated and there's insurances put in place to pay out, so they can be.
Now we will move over to Victoria, who specialises in wills and probate. Your technical question is, how often and in what circumstances should people be updating their wills?
How often? I would say that everybody needs to review their wills every 5 to 10 years. The reason for this is to make sure that it still does what you want it to do, that it encompasses any changes in your life, and that it's still the most tax efficient that it can be, because tax is ever evolving and changing, and often tax method that may have existed yesterday might not tomorrow. So it's best to check it for that. But on top of that, circumstances that can occur could be anything from moving house, losing somebody, giving birth to somebody, getting married, getting divorced, occurring new assets, liquidizing assets. All of those events are things that should trigger you to review your will to make sure that it still encompasses all of the assets or events. And if it doesn't, you can update your will. Or if it does, then you're okay and you just need to review it again in the event of a changing circumstance.
I think there was an interesting thing that you mentioned not so long ago, Victoria, about legislating for who looks after your children in your will. Because I think most people, when they think about their wills, they think about their assets and they think about, you know, who they're going to leave their financial assets to, and don't necessarily give as much thought about the children, because there is an assumption about who will look after their kids in the event that they pass away. So maybe you could also just touch on that so people are aware of what to think about there.
In very simple terms, a will is very useful to state who you would like to be your guardians in the event you should pass away, and this would cover children up to the age of 18. One thing, without going into too much sort of detail, is parental responsibility. So is whether the mother or father, the other person to you, has parental responsibility, and whether they would automatically get the children on your demise. So one, you need to consider that. Two, if you're married, for example, and God forbid something happened to both of you, obviously you need to have to cater for in the event neither parent survived. But as you pointed out, Leanne, there isn't an automatic right to any relation, next of kin, to get automatic rights to look after children. And in the event there isn't anything, then social services would automatically legally take care of the children, and you would have to apply to them and to a court to change it. So it may be a matter of going through the process, but that's still a process that you won't need in a time like that. Mm. So it's a very good idea if anybody has children to have that considered, discussed, and then put what's appropriate in the will to cover it.
Moving over now to Mr. Ristic, who works in residential conveyancing. Your first question is, what is involved in a property search? And what if somebody wants to do this themselves? I think I should probably add there that you can't really necessarily choose to do it yourself as such. Perhaps that means that they just choose not to do a search.
Very good question raised by it, but I wouldn't disagree with you. I would not agree with you there, Leanne. You can absolutely go and do your own searches. Anyone can commission an official or a personal search, but for a bit of background quickly, all resi and commercial transactions of any purchase generally involve some form of searches for basic things: drainage and water, local authority search to see if, for example, it's a listed building in a conservation area where other rules and regulations could apply, plans for the local area, also environmental considerations like, is it built on contaminated land? And any of those could impact on the value of the property, its mortgageability and its saleability, or more importantly, if you're a purchaser, whether you want to proceed with the purchase at all if you find something nasty that turns up with it. But people can commission their own, but the risk of it is very simple. If you're buying with cash, and Leanne raised a very good question there, yes, you can probably get indemnities for protecting a mortgage lender or a buyer for no searches, but that will only cover the local authority search with any adverse entries, and drainage and water. Things like environmental planning and stuff like that, you'd have to do your own research. And if you had a mortgage lender, they very simply, they won't accept anything that isn't either insurance backed or an official search from one of those providers. So it all boils down to the risk you take and what you want to insure against. And usually what's good for a mortgage lender is usually good for a buyer as well. Those rules are very good and tend to protect all parties in the transaction. But more importantly, if you're buying something, surely I would like to think you would want to know all about that property. It's not just about the bricks and mortar, it's about the rights, what's going on around, what it's built on, and what bit of its previous history is. And when you don't know that, and then all of a sudden you want to deal with the property, like sell it again or flip it or develop it, we act for a lot of developers as well, the last thing they want to hear about is a contaminated land entry because you never bothered getting the searches beforehand. You could almost devalue the land immediately. For the cost of a searches, £200 to £300, maybe £500 to £600 for commercial searches. But more importantly, the expertise of the legal department to interpret those results rather than you trying to guess what the answers should be or not be. That's where the value lies, your time, your money and your costs. So always recommended to get a lawyer to check over searches properly, mainly because they've got the experience to analyse the results that come through.
Yeah, I think that's actually a good point. You know, the cost of the searches versus the cost of the asset that you're acquiring, and what it could cost you if you miss something in buying a property.
Absolutely.
You know, it just feels like an absolute no-brainer. Why on earth would you save?
Absolutely, yeah. And the cost of an indemnity policy is not much less than actually getting a full suite of searches. Yes, you can get an indemnity policy by click of a button, but the reality is it only protects against an adverse entry. If that adverse entry is onerous, then, and you, for example, it's been built on contaminated land, and I've had a few of those in my conveyancing experience, you watch the transaction just collapse immediately. You'd rather know before you spend your own money. Absolutely, Leanne. Cost is trivial compared to the value of the property as a rule.
Okay, so moving on to my technical question. Somebody has asked, what is the difference between a merger and an acquisition? And also, what is the overall process? So if I look at the first part of the question, what's the difference between a merger and an acquisition? Well, an acquisition is just another word for a purchase. So if you're taking part in an acquisition as buyer or seller, you are either selling the shares in your company, or the company is selling its business and its assets. So there's two different ways in which an acquisition can take place. And generally, you know, a buyer or a seller would choose whether to sell the shares or choose whether to sell the business and assets based on risk and also the tax efficiency of the different methods of sale. But that's a conversation for another day. You can also get smaller kinds of acquisitions. So, you know, it might be that a shareholder is exiting the business or is incoming into the business. And so one person's shareholding is being sold as opposed to the business as a whole. Z Group has actually done a number of acquisitions over the course of its lifetime. All of the acquisitions that Z Group has done so far have been on a business and assets basis, where the companies themselves have sold their business and their assets, so their contracts, their fixtures and fittings, etc., etc. And I was actually introduced to Z Group and started off my life at Z Group as an external legal advisor, giving advice on those purchases. That is different to a merger, because in a merger, no one party is buying the other. It's effectively two parties that are joining together for a combined business. And you often hear that term specifically, I think, in law firms, you know, where you hear that this firm and that firm has merged. So in that situation, there's not necessarily any money that's changing hands. One party is not buying the other out. However, the term merger can also be used actually as a little bit of a political phrase, where parties don't want to actually admit to being bought out. So the actual legal process may well have been one party buying the business or the shares of another party, but because they don't want to let the world at large know that, the way that it's kind of communicated to the outside world is that it's been a merger.
I certainly use that quite a lot with Bull Craigs, because it's just easier explaining to their old clients, yeah, we merged with Bull Craigs, rather than, yeah, we bought them. So it's quite handy from, as you say, a political point of view to use that word when it's not technically true.
Yeah, I think some people would associate something negative with being bought out.
Yeah.
But to be honest, that's probably only in a situation where there's some kind of financial difficulty. You know, buying another company is a perfectly valid growth strategy. You know, lots of people grow by acquisition. And you know, there's no shame in being bought out by a competitor or to join a larger group. But yeah, sometimes you do see merger being used for political reasons rather than actually reflective of what's happening. The process, the best way I can summarize the process is a little bit like buying a second-hand car, not from a dealer, and that is buyer beware. You know, when you are acquiring particularly the shares in a company, you acquire it warts and all. So if it's got a whole host of hidden liabilities and you haven't investigated those and built protection into your purchase agreement, then you are going to get stung. Because when you buy the company, you naturally inherit all of the liabilities that it has. So you do what we call some due diligence, first of all, to try and flush out any issues. Assuming there's nothing that's going to be a deal breaker, you then move on to the contract process, which is what are we selling, how much are we paying, when are we paying for it. The due diligence process is formalized in something called warranties and disclosure, which is a little bit like a confessional. So warranties are statements of truth about the state and condition that a business is in as at the point of completion. And if any of those statements isn't true, the sellers have effectively the ability to confess or disclose against those. And if a disclosure has been made and something goes wrong in the future that relates to that, then the sellers are off the hook because they've told the buyer about it prior to completion. Generally involves a negotiation between lawyers, and also a little bit like property transactions, if there's a lender involved, you might also be negotiating with the lender's solicitors as well. Somebody is dying to know, what is the Magna Carta?
Oh, yes. Well, to quote my second year of primary school, the Magna Carta was signed in 1215 at Runnymede by King John. What that really means in a legal sense is there are a lot of arguments between King John, the Archbishop of Canterbury, and the noble lords. Because King John, as we all know from watching Robin Hood, wasn't very nice and would steal from the poor and give to the rich. That's what I believe. That's what Disney's told me. So the lords were a little bit annoyed and started revolting against him. And they came up as a peace process, which wasn't very successful, but they created the Magna Carta, which was essentially taking a lot of the power away from the monarch and giving it to the people of sorts. So it's seen as a kind of an early running point of our constitution, even though we don't have a written constitution. So backbone to the English legal system, really. It's been repealed over time. There's only 3 clauses left, but as it's been repealed, it's just been updated. One of the 3 clauses left is the right to trial by jury. So just something from back then that still to this day exists. So that's the Magna Carta. It's also been used across the world. So the American Constitution or Bill of Rights, or whatever it is, it kind of took its origins out of the Magna Carta. So you can see its origins throughout the world. And
as you can tell, Mark went to a very forward primary school. I was learning how to count to 10. I was learning colours. I was doing an egg and spoon race. Mark, on the other hand, is learning about the Magna Carta at 6 years old. I mean,
it's unfortunately true. That's what it was like. Then again, the map on the wall in the third year still had Ceylon instead of Sri Lanka, so it was very much not forward thinking. It hadn't really caught up since the 1930s.
Okay, moving on then to Victoria. Why did you choose to specialise in wills and probate as opposed to other areas of the law?
Very good question. I did work in other fields of law. Criminal was my first area, which I quite enjoyed. Worked on a murder trial, unlawful imprisonment and counterfeiting all at the Old Bailey, which was all quite interesting. For various reasons, that wasn't the field for me long term. So I then tried my hand at conveyancing a bit. Sorry, Mark R, but I hate it. So I stopped doing that.
For everybody, Victoria, it's not for everybody.
You got a little taste while Mark was on holiday for my exchange, and
Yeah, a little
thoroughly
reminder.
enjoyed that.
Oh my God, I hate this field of law. So then, because of my law degree, I did specialise in a few areas, private client being one of them. I went back to that, and that's kind of where I've stayed for longer than I care to remember. It's initially, I like doing it because ultimately I'm helping someone, particularly at times where they need help. And that ultimately, without being a bit cheesy, is why I went into law, because I wanted to help people and to actually make a difference. So I feel I am in this field. So that's it.
Very good. Mark Ristic, 2 answers that are not allowed to this question are lunchtime and home time. So with that in mind, what is your favourite part of your job?
It's actually an easy one. I have the pleasure of talking to many clients over the course of a day. I was even late to this meeting because I was on the phone to clients. And with all my client interactions, that the whole goal of Resi, commercial and everything, whether developers or whatever, is about getting their transactions completed. And easily the best part of the job is making that final phone call to, should we say, when you bought your house, that your client is now a new homeowner and they can go and collect their keys from the agents. I could probably write a book on the types of reactions. I've had everything from stunned silence to tears to whooping with joy. And when you're on the other end of that phone, it is absolutely brilliant to hear, because there's usually been a long, sometimes a torturous process, sometimes a nice straightforward one, but either way, they're over the moon that they've got their new property or transactions finished, and listening and hearing, or sometimes rarely, but now and again, seeing their reaction face to face is absolutely superb. And that's just gives you a rewarding feeling that you've done what you said you were going to do. Job done. And it's always nice to hear that reaction or see that reaction.
The last one is my question. Why did you choose to become a solicitor instead of a barrister? For anybody who is unfamiliar with the difference between the two, the main difference is that predominantly a barrister's work involves being in court. There are solicitors who can do court-based work, but it is much less often than barristers. So that's the difference. 3 reasons why I didn't want to become a barrister. The first, not long after I left university, one of my university friends got married and we went on a hen do, and she decided she wanted us all to dress up as Queen's Counsel with the wigs and the gowns. And I just thought, this is not really a look that I'm going to buy into every day. You know, those who know me know I've got a bit of a relaxed style in the office. So I'm definitely not donning a wig and gowns as part of my daily routine, basically. So that's... Sorry?
You like the horsehair.
Did I?
You like the horsehair. The wigs are made of horsehair.
Oh, well, these were actually just polyester from eBay, but you know, they gave me a good enough idea of what it was going to be, like. Second reason, I had a very vivid memory of doing some work experience when I was at university in a firm where it was actually the solicitor who had to go into court. It wasn't a barrister, but she did have to go into court. And she was wearing a skirt suit. And she came back in floods of tears because the judge had humiliated her in front of the whole courtroom by suggesting that her skirt was far too short, you know, and that she was really causing offence to him as this, you know, high and mighty godlike person. And I asked her how she responded to that, and she said that she apologised. And I just thought, you know, I'm not a big condoner of violence, but I'd have probably smacked him in the face. And so, you know, probably not good for me to go into that particular area. And then finally, I think just for my own general mental health, being a barrister generally means that you're going to court and you're arguing about something. You know, someone's going to win, someone's going to lose. And I don't particularly want to be arguing all day long, every day. You know, corporate law is more about working together with people to achieve something, you know, like Mark says, like a sale, an acquisition. And it's quite a good feeling when you get to the end of that process and you know, somebody's bought their business or they've exited from a business that they've worked on for however many years and they're retiring. That is something that I really enjoy doing. Not arguing about the fact that delivery's been late and it's cost this much and now you're going to go to court to fight about it. That is not really my bag. And so that's why I chose to become a solicitor.